Hi, everyone. My name is Jamie Brandis. I am with the Colorado Small Business Development Center Network's SBDC TechSource Commercialization Program, which is a big mouthful. But I would like to welcome you all today. This is Introduction to Boards of Directors, and we are glad you can join us, and we're happy that you could be here, and we hope you get some takeaways from this presentation today. Really quickly, I would like to introduce you to our Colorado SBDC TechSource program. This is designed to help support science and technology ventures throughout the state of Colorado. This is different from many accelerators and incubators that lead to equity funding, where you would give away a piece of your company, where we focus especially on non-dilutive sources of capital, where there's no equity given, and on technology commercialization and small business innovation research grants. Our program is specially designed to tap into subject matter expertise. This includes the attorneys that you have today with Sage Law Group, to provide you, who are mostly science and technology entrepreneurs and companies. We help all stages from pre-startup through advanced second stage with direct assistance. And we do this in the form of customized expert consulting, which is at no cost to you, as well as workshops and events in person when possible, but this year everything is online. And we also do some accelerator programs. Some of the topics that we cover through this program are those SBIR grants that I talked about, as well as advanced industry grants through the state of Colorado. And we help with R&D tax credits, technology commercialization, IP protection, market research, market sizing, strategic and tactical planning, access to capital, and much more. So these resources are available thanks to support from SBA's FAST program, Visa, Colorado Office of Economic Development and International Trade, the Minority Business Office, Zero, and the City of Boulder. If you are a business located in a rural part of Colorado or are minority or women-owned, we may have additional resources for you. So please reach out to us and we're happy to help. Just a few quick things for today's webinar. After this, if you are interested in meeting one-on-one with one of our specialists or attending workshops, events, or webinars, please visit our website. It is sbdc-techsource.org, and that will help you get started. Today's webinar is being recorded, and you will receive an email following this with a link to the recording as well as a copy of the slide deck. Just a few housekeeping things. Everyone is currently on mute. If you have questions, please type them into the chat bar, and we'll try to get to them at the end. We will leave quite a bit of time for Q&A. So if you don't get your question answered today, we will try to follow up with you afterwards. So now I would like to introduce you to today's presenters, Carrie Schiff and Alice Warren Gregory. To give you a little bit of their backgrounds, Carrie is currently the chair of the Governor's State of Colorado Economic Development Commission. She's as well as the co-founding partner of Sage Law Group. She's a business lawyer specializing in the representation of technology companies and their investors in corporate securities and transactional matters. As both a seasoned business executive and outside counsel, she has participated in the development and execution of commercialization strategies for a range of companies, from global multinational companies to startups. She represents clients in a wide variety of industries, including manufacturing and supply chain, data and geospatial imagery, technology, alternative energy, e-commerce, and digital gaming. Alice Warren Gregory is a corporate securities and commercial transactions lawyer who serves as outside general counsel to her clients. Her practice runs the gamut of business law, from advising new companies on entity formation and corporate governance issues, to helping establish companies as they grow the business through mergers, acquisitions, or financings. She also represents investors and investment funds in connection with debt and equity investments, joint ventures, and other strategic transactions, as well as general corporate matters. So now I will turn it over to Carrie to get us started.
Thank you so much for that kind introduction, Jamie. There's one thing that you left off. I always like to say that at Sage Law Group, we are SBDC superfans. We think that the services that you provide to the entrepreneurs in our community are really unparalleled and so supportive. So I wanted to say that. I also have one little commercial, which is for the Colorado Office of Economic Development and International Trade. You should all definitely check out choosecolorado.org and see what other kinds of non-dilutive financing might be available for your company at the state level. So take a look. And with that, I would like to welcome you to our presentation. Our task here is to really give you a general overview of what a board of directors is, what they do, who typically serves on them, and how they differ from advisory boards, also talking about what they do and who serves on them, et cetera. We have found that it's an area that can confuse many companies. And so what our goal is if you leave this presentation understanding the difference, we will have been successful. We will leave time at the end if you have questions. My only request is that if you do have a question, if you could ask it generically, don't name names, don't even name your company name. We are attorneys and we have professional duties that would require that we cannot give advice that could be counter to one of our own clients. And so we don't want to worry about having to check conflicts before we can answer your question. So with that, we'll begin. So I will turn it over to my colleague, Alice. Go ahead.
Hi, everyone. So this is kind of our little cheat sheet here. And don't worry, you don't have to memorize it because we're going to show it again at the end. And we'll leave it up for a while so you can kind of digest what you're seeing. But this is kind of a brief overview outline of the significant differences between boards of directors and advisory boards. And as you can see, boards of directors have some significant differences from advisory boards. The board is legally required to exist. It has decision-making authority with respect to decisions within the company. It is elected by the shareholders. It has fiduciary duties to the company and the shareholders of the company. It does not give non-binding advice. That is something that an advisory board does, and that's one of the significant differences between advisory boards and boards of directors. Boards of directors and advisory boards both meet, and that's how they make decisions or render advice. And they both typically receive some kind of compensation for their service, whether that's cash or equity compensation.
Thank you, Alice. We wanted to pause very briefly and talk about the different kinds of entity structures because in our experience, I would assume that a good proportion of the companies that are represented by you all could have been formed as what we call a C corporation or as a limited liability corporation or as an S corporation. And the kind of entity that you chose to form is going to dictate some of the vocabulary that we use when we talk about boards of directors or we talk about the governance structure. The primary difference between these entities is the tax treatment of the entity itself. That's well beyond the scope of today's conversation, but I wanted to just sort of briefly touch on that. We will discuss the difference in governance or in what a board looks like of a C Corp. A C Corp, we'll call it C Corp / S Corp versus a limited liability corporation further on in our discussion. So Alice, I'll turn it back to you.
So we're going to start with discussing boards of directors. With respect to C Corp and S Corp, as Carrie pointed out, we're going to begin with those. Every corporation is legally required to have a board of directors, even if the board only has a single member. The board is the highest authority in the corporation, which means it is the ultimate decision-making body within the corporation. And its primary duty is to protect the shareholder value. So to make sure that the company is delivering value to its shareholders. The board of directors is not responsible for the day-to-day management of the corporation. Those responsibilities are typically left to the officers of the corporation, and the officers may or may not serve on the board, which we'll get to in another slide. And the board of directors acts at meetings or by written consent. So the decisions that it makes in the context of meetings of the board or written consents, which are basically just documents that state what the decisions that are being made are, and then that they were agreed to by the board.
So Alice mentioned that the board's role is to be a steward for shareholder value. Another way that we think about that is we say that the board has ultimate oversight responsibility for the company. And in practical terms, that breaks down into two categories. And I kind of combine them here in this slide. But one category are the decisions that by law, and this is by law, what I mean is like in the state of Colorado or the state of Delaware, which is a state many corporations are incorporated in, there are statutes. And those statutes actually say what the board must decide, what decisions have to be approved by the board. And those on this list would include things like approving the creation and the sale of equity. So when you want to sell stock, the way to do that is the board approves the creation of the security and the sale of the security. And the actual documents that create that security are the articles of incorporation or the certificate of incorporation, depending on what state we're talking about. And then the actual sale are purchase and sale agreements, contracts. Others examples of statutory requirements are the requirement to approve and pay dividends, recommend mergers and acquisitions. And then I call it compliance oversight, and that's not statutory, but there's case law that says that the board of directors is responsible for overseeing a company to ensure that they have a compliance program in place. So if you have legal requirements you must comply with, let's say you're a biotech company and you're creating a pharmaceutical product and you're complying with FDA regulations, you need to have policies and procedures and rules in place that your employees have been trained on that they follow. The board has oversight responsibility on that practice. The other thing that the board typically does, these are what we would call good governance, is they are responsible for things that are of such a material level that the board really needs to be weighing in and deciding. Things like hiring and firing the CEO, approving the company's financial statements, entering into a major joint venture agreement with a company, incurring substantial debt. So I don't mean setting up company credit cards. I mean taking a loan from Silicon Valley Bank, things like that. So just a couple of practice points for you. You may have formed a C Corp or an S Corp, and you may be the only owner. You are likely then the only board member. If you are the only board member, you don't need to call a meeting with yourself to make these decisions. What we would recommend is, though, you write what we call resolutions, or you write out what the issues are that need to be approved in a document that we would call a written consent, and you sign it at the bottom. So that when you are the only member of your board, that's how you would make sure to document these decisions. When you start taking other people's money, so if you get you get actually dilutive financing sources from venture capitalists or angel investors, they will likely expand the list of things that they want the board to approve. So just keep that in mind, and those things could include the company's budget for the year. The board may require that you do a budget and that they approve it in advance. With that, I'll turn it back to Alice to talk about, well, who's on your board?
So as Carrie mentioned, that was a great segue. If you're a single member corporation, you're likely the only person on the board. But as you start to take investment, you may have your investors on the board. So the directors are elected by the shareholders, technically by law. The members are usually founders of the corporation, might include the CEO, likely includes your significant investors. So if you have folks who put in some money, they typically want to be on the board because they want to have oversight over their money. They want to make sure that the decisions that are being made are in their best interest and in the best interest of the company. And typically that would be a term that they would include when they were negotiating the terms of their investment. You might also have what are called independent directors. Those would be people who don't necessarily have a direct financial stake in the company. They are not employees of the company. They may simply be people who have business expertise or other expertise that's useful, or they may be people who have great connections that you would like to leverage. And those people would be able to help with, the governance and the oversight with a little bit of a different perspective, as they are not major investors in the company and they are not employees of the company. They will tend to look at things slightly differently and therefore may be very valuable in terms of the insights that they can provide.
So Alice mentioned when she ran through the chart that one of the very critical distinctions between a board and an advisory board is that the board is actually making actionable decisions. And I highlighted for you a couple slides ago some of those decisions that either by law the board is required to make or as a matter of good corporate governance the board typically does make. When the board is taking action, they are taking that action in the context that they have by law fiduciary duties to the company. That means that they need to be considering the interests of the company ahead of any other interests they may have personally that could be affected by what those decisions are. A good example of where that conflict could arise is if an investor invests money in your company and then they want to sit on your board, when they are making decisions that affect your company as a board member, such as deciding the company needs to raise money and sell more stock, that individual director is obligated to consider the interests of the company first ahead of their investment fund that they are representing as a designee on your board. Those fiduciary duties, the duty of care and the duty of loyalty, are the subject matter of many lawsuits. This is an area where when you hear about class action lawsuits and boards of directors being sued because of they approved a merger, for example, or the company has decided to raise money, or the company's financial performance has fallen off a cliff, these directors, when they get sued, they are being sued typically for a breach of these fiduciary duties. So I want to underscore the importance and the seriousness of and the level of responsibility that the law will hold those individuals who are serving on your board. Just a quick practice point for you, if you ever are asked to serve on an actual board of directors, an important thing for you to do is to ask the company how they protect board members from those issues, from those lawsuits that can arise when you're exercising as a responsible person your good business judgment. And the ways that companies protect their directors and their executive officers are through what we call indemnification of their board members and officers, which shows up in language in the articles of incorporation, the bylaws, and maybe contracts with those people, and then through insurance. And I'm only mentioning those things because I want to reinforce that this fiduciary duty is really important, and it winds up being a very significant distinction between the responsibilities of board members versus advisory board members. So with that, I'll turn it over to Alice. How do we pay these people that we impose all this liability on?
So typically, the compensation will, of course, depend on which type of board member we are talking about. If we're talking about a founder or an officer of the company, they're typically not going to receive any compensation specifically for their service on the board. They're usually already receiving a salary from the company. They've typically already received some form of equity, either in connection with the founding or as an incentive for their employment as an officer. Investors who are members, again, they're serving to some extent to keep an eye on their money. And so typically they're not receiving separate compensation. They may have their expenses reimbursed, for example, if they have to travel to attend a meeting, or the time that they have to spend on a meeting, they may receive some, cash reimbursement for that. For your independent members, those folks will typically receive some kind of compensation. If it's an early stage company, they might not receive anything simply because, it's very early in the company's life cycle and there's not much to go around. And so they might receive nothing, or they may receive stock options, which would be quite common as well. And then for a more mature company, they may provide cash, either on a per meeting basis or sort of a one-time retainer. And they may also receive stock options as well.
So what about LLCs? So LLCs, as I mentioned before, the difference between an LLC and a C Corp or an S Corp is the primary difference is tax. So LLCs have a single layer of tax. You are only taxed on your personal income tax as opposed to the corporation paying a tax as well. Many of you, when you first start, you may form an LLC as your legal entity. You're the sole owner of it. It's a single member LLC. You may have just gone on to the state of Colorado website where you can register an LLC for very little money. It's like a one-page form. Same thing for Delaware and most states. Those LLCs, when you make that election and you choose to go that route, that comes with it a different governance structure than a C Corp or an S Corp. By law, LLCs don't have the same governance requirement by statute that C Corps and S Corps have. We call them, as lawyers, we say they are creatures of contract, which basically means you make up your own rules. And there is a statute in both, every state has a limited liability corp statute, but it's more optional, fill in the blank if you haven't made certain selections. There's two basic ways you can structure an LLC. And when you first start out and you just filed that form with the state, you're typically a single member LLC, and we call you member managed. You have no other governance structure. It's really just you as a member owner. Member is equivalent to, say, shareholder. So it's as if just the shareholders or the members have all of the responsibilities that we described before for making the decisions that in a C Corp or an S Corp, the board would be making. In the LLC, you'll be making them. You should document them. You should respect the difference between you as a person and your legal entity that you're managing. The other option, when you have more than one owner, is you may decide you want to become what's called manager managed. And that's a term that really is, in our view, equivalent to having a board. So a board of managers is like having a board of directors. And you want to think through the exact same kinds of issues that you're thinking about when you're running your C corporation in terms of what do you want to say that those managers or that board of directors or board of managers, what decisions will they need to make instead of the members making? And the rules that you decide amongst, and how do those rules get decided? Well, they're negotiated. They will be negotiated by you amongst yourself with the investors that you're bringing in, the other owners that you're bringing in to your company. And where do you write those down? You write them down in what we call the operating agreement. An operating agreement for a limited liability company is essentially a combination of the articles of incorporation and the bylaws of a regular C corporation. The articles are where the description of the stock that you've created and the rights that stock has to vote or to have distributions ahead of other people, or other kinds of protective provisions for the stock. Those are laid out in the articles. The bylaws are like the rules of when do we meet, how do we meet, what are the approval requirements for when we meet, like what constitutes a quorum, meaning how many people have to show up, then how many people have to vote in favor, et cetera. So those two things combined become your operating agreement. And as an LLC, you have to actually make decisions about governance and how those rules will be applied. The other thing is you have to make a decision about those fiduciary duties I talked about. In an LLC, you do not actually have to have all of the fiduciary duties that in a C Corp you would have. There are good things about that, meaning it lowers some of that liability risk, but there are bad things about that. It also means that people can behave in their self-interest in a way that they wouldn't otherwise if you impose those fiduciary duties. Our recommendation always with LLCs is to ensure that we are protecting the board members or the people in that board of managers role and the officers, is we think really in terms of aligning those roles and responsibilities contractually the same way we would have if the statutes were in place when we were looking at a C Corp. So that's the major difference. You actually have to make more decisions with the LLC, but you also will, if you want to be selling stock, you want to be doing those things, you're going to need a governing body or an entity to help make those decisions. So with that, I think we can start talking about advisory boards now in contrast. Alice?
So what does an advisory board do in contrast to what a board of directors does, either because they're legally required to or because they have been given the authority to do so? An advisory board is an informal body. It is not one that is required by statute. and it can be created for any type of entity, an LLC, a C Corp, an S Corp. Again, it has no legal authority, so it cannot make decisions on behalf of the company like a board of directors can. It's not legally required. There is no statute that says you must have an advisory board. And in addition, it has no fiduciary duties. So these folks do not have a duty of loyalty, a duty of care. They don't even have a duty of confidentiality. So it's a very informal, kind of loose group of folks who are going to provide non-binding advice. And again, it is completely within, as the founder of the company or as the officer of the company, it is up to you to decide whether you would like to have an advisory board.
So I know that advisory boards can be incredibly useful and can be incredibly popular, especially for early stage companies. They can do things like provide you with additional subject matter expertise, coaching, access to a customer base that you might not otherwise have. They make introductions for you. There's sort of that extension to your operating group, but it's a more of an informal. And these are people that they don't want a job with you, but they might be willing to help. What we recommend is that you have an advisory board. When you think about your advisory board, you get very specific about your expectations for each person. What is it you want that person to do for you? And you write them down in an agreement. And that agreement should say, here's what you're going to do for me. It could be, and I've done this for companies where it's a page or 2 pages or longer, depends. But it could be, you will show up to X number of trade shows this year. You will show up to X number of advisory board meetings this year. You will spend X number of hours per month with the CEO. So as sort of objective, if you can objectively describe what you want your advisory board members to do for you, and then outline them so that everyone is clear on those expectations, because ultimately what you want to do is manage those relationships, manage those advisors the same way you would manage an employee. You want to make sure that you are getting the value that you are expecting from them, and you have a way of measuring that relationship and that value. And that's going to become important when Alice when we talk about compensating them. The other important reason to have an agreement is you do want to obligate them to keep all of the information they learn about your company confidential. And so that's the other piece that would wind up in your advisory board agreement, is a little confidentiality provisions that talk about that they have a responsibility to maintain the confidentiality of your agreement. So again, best practice, have an agreement that outlines specifically what your expectations are as objectively as possible, so you can measure whether this relationship is working for you. So who are those people?
You would expect, based on the types of duties that we just discussed, the things that you're expecting of your advisory board, that you would want to target folks specifically who have expertise in those areas that you're hoping to kind of beef up your company in. So you want people who are experts in your industry. Maybe you want subject matter experts, so people who are pros at marketing or sales or finance or HR, who can kind of help fill in some of the gaps in your company in those areas. Especially early stage companies won't typically have a lot of that type of infrastructure, so it's very helpful to have somebody come in who can give you some guidance in those areas. You may also want to have folks who are serial entrepreneurs. They've been there before. They've done this. They've built teams. They understand operations. They understand how to build a company culture, and they can help guide you in those ways where you may not have, again, sort of formal guidance. This is somebody who's been there, done that, and they can help guide you a little bit and give you some advice and almost act as, in some ways, as a mentor.
So how do we pay them? And you'll notice we didn't actually give you figures like how much would you pay a board member or how much equity do you give a board member. The answer to that is it really depends on the stage that you're at, the person that you're talking to, how important they are to you. I would gauge it at not necessarily you're giving out equity VP level percentages, but maybe director level or manager level. So not huge amounts of stock. The difference in when you're compensating an advisory board member or a board member with equity is typically your vesting schedule is much shorter than the vesting schedule that you would be giving an employee. So instead of 4-year vesting, you might do 2 or 3-year vesting. So what are other ways to compensate your advisory board? I know plenty of people who serve on advisory boards just because they want to put it on their resume or their CV. It's something that I think people are proud of, that they are being asked to leverage their experience and skills to assist someone. And sometimes just the bragging rights of being able to say that they're serving on your advisory board is enough to get them interested. In early stage companies, when you have advisory boards and cash is critical, it's typically equity if you're going to give any kind of compensation at all. And then more mature companies, as we've mentioned before with board members, they may also give some cash stipend, but it's unusual. What my experience has been is that the folks who are serving on advisory boards are usually so advanced in their own careers that they are really doing it more for either a little equity sweetener, a little kicker for that, but also, frankly, to give back. So I wouldn't say that, in my experience, cash is a big element of compensating advisory board members. And frankly, I would think twice if you're an early stage company. If you have someone who's saying, I'll do it, but I'll be on your advisory board, but you have to pay me. That's probably more of a consulting relationship as opposed to an advisory board. And I would really want to focus on that more as a commercial relationship with that person, thinking harder about what your expectations are of what you're going to get from them in exchange for how you're going to use your precious limited resource of cash. Alice, do you want to go back to our chart for a recap?
As promised, we're back to our handy dandy cheat sheet here. So as we discussed, the board of directors, again, is going to be legally required by statute for a corporation. It's going to have decision-making authority, so it actually can make decisions that are legally binding on behalf of the company. The members of the board are going to be elected by shareholders as required by law. They are going to have binding fiduciary duties, duty of care, duty of loyalty, that will create potential liability for them, as we discussed. And that's why we talked about indemnification and sort of the ways that the company can protect its board members. As we discussed, the board of directors are not giving non-binding advice. That's the job of the advisory board. The board of directors, again, is making legally binding decisions on behalf of the company. The advisory board is, as we discussed, more informal, simply providing some strategic insight, some operational advice, things of that nature. Both the board of directors and the advisory board are going to be attending meetings and making decisions or rendering advice at those meetings. And they will both be receiving, they may be receiving cash or equity compensation for their service.
So with that, we would like to open up for any questions. So Jamie, you're gonna moderate questions for us?
Yep, I will do that. So I don't know if you want to answer these questions about B Corp or nonprofit, but there are some questions regarding if you need the same type of guidelines for those, or if there are differences that should be considered for if you are B Corp or a nonprofit.
I don't work with nonprofits, so I really can't answer that question specifically. Alice, is that something do you have experience with that? What little I know is that I think they do have fiduciary responsibilities, not to the stockholders, but to the stakeholders. It's different, but I do think that they are burdened by those. But I don't do that work. There's a great firm down in Denver that specifically focuses on nonprofits, and Jamie, I could share that contact with you after the meeting if you want to forward that name on to someone who can answer that question or needs that question answered.
Great, thank you. Okay, so this person is asking, is it possible to have a list of the activities that the board of directors is legally required to do? Like, is there a standard list that people can refer to?
It's actually the list that was in our slide number 6, which slides will be available. Those are approving and paying dividends, approving the creation and sale of equity, recommending mergers and acquisitions, and I would add to that hiring and firing the CEO, actually. And then the last one is not statutory, but it's the compliance program oversight. So those are the legally required. It's a really very short list. But there, again, I wouldn't limit my board to that short list. I would also focus on good governance, good corporate governance. What are things that a board really actually should be considering? And that's we're going to get into like the mushy area of, is it material? What does material mean? Is it really important? Is it something that could affect the company's financial position going forward, such as taking on debt? Could it affect the company's freedom to operate, such as agreeing to give exclusive rights to a third party, another contracting party to the company's technology? Whoa, I would want the board to weigh in on that. So anything that is really significant to the company, something that the CEO has to decide and be a part of, the board might want to be also, that may be something you want to take to your board as well.
Great, thank you. So then there's a question about firing board members. Is that possible for the board of directors, advisory board? Does that look different for each? What would that look like?
Alice, do you want to take that one? We call it removing, not firing. Removing.
Yeah. Typically, the manner in which a director is to be removed will be dealt with in the bylaws. So the company will actually have sort of a procedure for how that is supposed to be handled. It would be, again, typically you would have shareholder involvement with respect to that decision. So yeah, it's not as simple as firing an employee or, there has to be some procedure around it. And again, that procedure should be sort of set forth in the bylaws. And we wouldn't say fired for sure.
Well, I'll give you an example. I actually have a recent example where a client, the client is looking at pursuing a sale of the company. One of the board members has been, hasn't been showing up to meetings. And so they wanted him to resign, which is the typical way that, these are relationships and they're touchy relationships. And so my advice would be try and talk to the person early it's just like managing anybody. You missed 2 meetings, maybe, what's going on, or do you still have time for us? And see if you can encourage them to step down on their own. In this case, we actually explained to the company what the vote would be required in order to remove that director, and then refill the position with somebody else. And in the course of explaining to that person that they could be removed, which would be embarrassing, they did finally resign. So just sort of think about, the law shouldn't dictate relationship management. It's like, think about the relationship first and what's the best way to kind of work through that relationship bump in a way that preserves everybody's good feelings and goodwill.
Great. Let's see. So this person is asking, can a CEO terminate a member of the board for insubordination? Well, no. This is the whole issue of removal. So who is, you would have to look at, for that company, who elects that member. Like, are they serving because they're designated by certain investors? That could be a rule. That's why that person's on the board, or have they just been elected, by all of the stockholders to serve? I would, again, the CEO should feel free to talk to their board members about relationship issues, which insubordination sort of is a relationship issue. If the insubordination is something that is really an individual acting in a breach of their fiduciary duties, actually, Alice, do you want to talk a little bit about that? What if your board member is doing things that you might think are not in the best interest of the company? What would you do?
Well, I think it depends on what the misbehavior is. Certainly, there are some types of misbehavior that you would want to deal with formally. If you think that there's some kind of financial impropriety or some other type of wrongdoing of that nature, I would certainly want to handle that through as formal channels as possible, because obviously there's exposure for everyone who's involved in that, and there's also potential reputational damage. If it's more sort of the types of things that we're talking about, such as not showing up for meetings or just kind of not really fulfilling their duties, but maybe not necessarily actively harming the company, that would be a situation where, as Carrie recommended, I would try to talk to that person and resolve it in more of a relationship-based manner. But yeah, it really depends on the type of misbehavior that we're talking about. And I wanted to also go back briefly to the issue of removal, and something that Carrie raised that I think is important to discuss. So when you have members of your board who are investor representatives, so essentially those positions on the board have been negotiated on behalf of the investors. They've asked, because I'm investing this amount of money, I would like to require that 2 members on the board are, myself and my co-investor, or, folks who are elected by me. Their removal is usually dictated by the terms of their investment. So usually they can only be removed by a vote of their own shares. So that is certainly something to keep in mind. That is definitely something that gets negotiated with investments, and it makes sense. They don't want it to be easy to remove them because they've put money into the company and they're there to watch their money. So that's definitely something to keep in mind when you're thinking about sort of removal or any other improprieties or other issues. You're going to be potentially coming up against those types of requirements, and it can get a little, again, iffy because those people are investors in your company as well. They've given you money, so there's a lot more at stake there.
Alice makes a really good point, and I just want to grind that pencil a little bit more and think about this in terms of both the board of directors and your advisory board. These are relationships with people. And from the board, when you're talking about a board of directors, there are laws and specific rules in your articles and bylaws, et cetera, that are going to dictate the comings and goings of those people. So they are sticky in a way that requires certain actions to be taken to remove them if you don't like them anymore, if they just aren't showing, whatever reason. Same thing with an advisory board. You should think of it that way. It's a relationship. And you should, as I said before, we want to set clear expectations, and it's really good to have an agreement in place that covers what those expectations are and what how you're compensating them, et cetera, so that if they aren't performing, you actually have something you can pull out and say, look, I had wanted you to show up for me in this way and you didn't. And I think now is the time for us to terminate this relationship. And so I think for both sets of bodies you need to pick carefully, and you need to understand that it's really something you have to manage carefully.
Great, thank you. So I'm going to kind of combine a few questions into one. So it kind of goes into, how do you recruit board members? How important is diversity? How do you go about making sure it is diverse and you're meeting those needs? And also, in terms of governance of the board, how does that affect company culture? Can that have an impact on what the culture of the company is going to look like?
Alice, you want to start commenting, or?
Sure. I mean, as we mentioned, probably the most typical way that you end up with members on your board is that they are your investors, and they've required that they sit on the board in connection with investing in your company. So, that's not necessarily a choice about who's sitting on your board. That's more a choice about who you're taking money from, which you may have similar considerations when you think about, whether you want who you want directing your company, who you want to have a say. And it's smart to keep in mind that money always comes with strings attached. So And those are some of the strengths. In terms of recruiting independent directors, so those folks who are not already officers, employees of the company, or folks who are giving you money, you would look for them the same way that you would kind of tap your professional networks for any other type of position. So are there folks that you know in your industry, that are leaders in your industry, that you think would be able to give you, really good insight and advice on how to function within your industry? Are there folks that you know who, they may not be industry specialists, but maybe that they have great professional networks. They have access to lots of other people who can help you in different ways. Maybe they can introduce you to potential investors. They can introduce you to potential channel partners or strategic partners. So you want to think about sort of what am I looking to achieve with this hire onto my board, and how can this person help me achieve that particular goal? And I would say, diversity is another one where what is the purpose? Is the purpose just to be able to point to your board and say, we have a person of color, or we have someone who comes from a marginalized group, or are you looking to somebody really for their meaningful substantive input on things like company culture and how you can incorporate diversity into your company, in a more meaningful way? So those are the types of things that I would be thinking about. Is what can this person actually substantively provide to me and to my company? Not just optically, but actually, genuinely guiding the company in a certain direction, whether it's culturally or strategically, or, in some of the other ways that we discussed. Do you have anything to add, Carrie?
Yeah, I do. I think it's diversity at the board level is critical. I think it's really important. And when we think about, so I've been a general counsel of 3 companies, and culture, and I started this law firm, and culture is so important. Company culture, and it is absolutely tone at the top. And where is the top? It's the board. And I think having diverse views from is really important. And unfortunately, I've been doing this for 30 years, and it is a struggle and a fight to be able to open those doors and bring in those people. And so there are people that will meet those requirements, I believe, that you have in your advisory board from a subject matter area perspective, that are going to also bring diversity onto your board. And it's how do you find them? And I think there are consultants that work on that. There are headhunters that work on that. There are organizations, I think, that you can reach out to in addition to your network, which is also very important. And I think it's important that you put out there what you want. I want diversity, and I'm looking for people with these skills, so that when the seeds are being blown out into the wind, so you can find those people, you're specific about what you're looking for. The other thing, and this is going to be rare, but if you are a company and you are a fan, you're the unicorn. You're the one that is everybody wants to throw money at you. You have some power in that. And as Alice is pointing out, when the investors want to populate your board and the investors want to invest in you, you can put on the top of your top 3 things that are important to you when you're finding that relationship, that investment partner who's not just going to give you their cash, but is also going to serve on your board with you, that you want them to show up with a diverse representative to be on your deal team and to be then sitting on your board. This is a technique that when I was a general counsel, we were using in hiring law firms. Like, I want to know that when I hire this firm, there's going to be a woman or a minority who's going to be getting credit on the account from a financial, like money talks, but is also going to be leading that team and developing that team for me. So I was using my purchasing power to do that. And I think, and it's rare because, listen, sometimes you just need to get the check. But if you have the opportunity, it's a way to maybe help to influence that and communicate that requirement. And there are also funds out there that are being led by diverse founders that are looking for companies to invest in, that culturally care about the same thing, have the same values. And you should prioritize that money as well, because that, your successful company makes their fund successful, and that helps. That's going to help break this down. So that's what I would add to it. I definitely think it's very important, and we just have to find all the levers we can to be able to achieve it. It's not easy.
Great, thank you.
It's a passion of mine.
Yeah.
No, same blog group. We are 10 legal professionals, 8 women.
So I guess there's some concern about actually finding people in the industry and, doing the outreach to get people on your board. Like, do you have to put out enticements to try to get them interested? Is LinkedIn a good place to look for people in the industry? I guess, do you know best practices for finding those diverse individuals for your board?
Yeah, it's networking is my, the best relationships are, it may not be someone who's your first, your immediate friend, but it's friends of friends of friends. And so it's networking. However, whatever networking means to you, your business, your industry, how that is accomplished, that's what I would recommend.
Great, thank you. And then this question is about the perception of a board of directors versus an advisory board. So would you say that a company with a board of directors is perceived to be more advanced than just an advisory board?
No. Back to, I think, Alice's point in the very, very beginning, you have to have a board. You just do. Like, if you're a C Corp or an S Corp, you have to have a board. If you're an LLC, you either have to decide what your management structure is going to be, and either your members will act like they are the board, or you will have a board. You will set up that dual structure where you're manager managed instead of member managed or board managed. You have to have it. It's not, I don't think of it necessarily as a marketing or maturity issue. Like, hey, I've got a board, I'm real. It's more of if you have to have it. And some people use it, like some people market when someone joins their board as an independent and they're a big name in the industry or whatever. But, you just have to have it. An advisory board, I actually think a lot of companies really benefit from having them. They benefit from having these advisors. And those could be useful from a marketing perspective. Hey, I've got an advisory board. Look at my website with all these industry leading names or strong subject matter experts. It says something about those people have come, checked you out, validated your business plan in some way, or validated what you're driving towards your goals, and they've hung their name on that shingle with you. They're hanging their star with you. They're lending that to you. And it could be useful for that, but really it better be useful for the information and support they're also bringing you. So I don't think of it as a maturity thing. You have to have one, and you may really want to have the other.
So I guess as a follow-up, do you see companies that have both?
Oh, absolutely. They two totally different functions, really different functions.
Awesome. And then are the officers in the company also board members?
Alice,
They
you want
may
to
or
do
may
that
not
one?
be. Yeah, they may or may not be. Typically, you would see, for example, the CEO is often a member of the board, but again, it's up to the company to decide whether it's appropriate to do that. Again, if you're the founder of the company and you're also the CEO, of course, you would want to have a role on the board so that you can, kind of be a part of that decision-making process and have some say in it. But again, it's really kind of up to the company to decide how to structure it.
Great. So then,
and I would say, as a company matures, you should not have more than the CEO on the board. You might, in the beginning, have maybe there's 2 founders or both on it, but have that conversation early. Which one of us is going to have to drop off? Because over time, you'll wind up with just one, and that can get sticky. People's feelings can get hurt.
Yeah, again, you have to keep in mind that the board is tasked with things like removing the CEO. So if the CEO is also on the board, that can get very uncomfortable.
So as a follow-up to that, what is the legal process to appoint myself as board for my LLC, as the owner, CEO?
For your LLC, we would draft it up in your operating agreement. It would say you're going to be manager managed, and the sole manager is fill in your name. And your responsibilities are going to be list them. It's that simple. And that's your operating. Yeah. Go ahead.
Typically also when you file your articles of organization, that document that you file with the Secretary of State that creates the company, there is usually a checkbox that says whether the entity is going to be member managed or manager managed. And so that's something to keep in mind. If you've already formed your company, you may want to go back and look and see what you did on that document. A lot of people don't know the difference when they're forming the company, and so they may choose member managed. So it's a good thing to go back, look back if you've already formed your company, what did you do? And then does your operating agreement properly reflect what you filed with the Secretary of State? If you haven't done it, that's a decision for you to make, whether you want it to be member managed or manager managed. But that is a decision you typically have to make when you file the documentation.
But you can change your mind later too. You can file it as member managed, and then you can become manager managed. It's easy to do.
Great. Then this is the question, it's probably just put in the agreement, but are there kind of rules of thumb, like how frequent the board meets, how long the commitment typically is, how many meetings they're allowed to miss, that type of thing?
Boards for really early stage companies might meet monthly. They definitely meet quarterly. They should meet quarterly. I've had boards that didn't meet for years. Not good governance. And then, some of the shareholders started fighting with each other. Not good governance. Like, have your meetings. It's important for protecting you personally and individually that you respect corporate governance. So you don't have to write into any document, here's how often we'll meet. You can write into the document. If you write it into the document, whether it's in your bylaws or if you're an LLC in your operating agreement, and then you don't follow through, that doesn't look good. So we would recommend don't write it into the document, but come up with a plan for how you're going to do it. Board meetings actually create really good discipline for companies because on a regular basis, you have to be prepared to talk about what the company's financial condition is and what your progress is towards achieving your goals for the period, whether it's that quarter, that month, or that year. And it's so having to meet with your board to talk through those issues can help keep you on track. And if you make that a routine practice, it can help you move your company forward. It's a good tool for you.
Fantastic. Thank you guys so much. We're about up on time. So if there are any, I think we're pretty much answered most of the questions here. Did you have any final thoughts that you wanted to give to our audience today?
Boards are different from advisory boards, and you may have both. That simple.
One is legally required and the other is not.
Got it. Well, thank you both so much. So I would say Sage is one of our partners here that we are able to provide some assistance to clients with an hour that I would say on that meeting. So I'm happy to talk about that if there are audience members that would like to meet. We can't offer legal advice as an SBDC. I always have to give that caveat. So it really is just talking broadly through some topics, through some things you might want to think of for your own situation. So if you are interested, reach out to me or go to the TechSource website, sbdc-techsource.org. We do have some paperwork that you need to fill out, and then I'm happy to make some connections there. If you did not get your question answered today and want to follow up, we will be sending out the slides and just a follow-up email. So happy to get connected after that. So thank you, Carrie and Alice. It was really great to have you here today.
Thanks so much. Thanks, everybody. Have a good day.
Thank you for having us.
Yeah.